好，尊敬的各位领导、各位来宾，欢迎大家继续来到我们的论坛的现场。接下来我们即将开始我们今天论坛的下半部分的议程。在下半部分，首先给我们带来演讲的嘉宾是原牛津大学三一学院院长、国际刑事法院行为准则委员会主席、国际田联职业道德委员会主席、英国体育法协会主席 The Honorable Mr. Michael Belliff QC 为我们带来奥运中的伦理问题演讲。大家掌声欢迎。
I must start by saying what an honor and privilege it is to address you in this well-timed conference in one of China's fastest-growing cities, organized by the distinguished Guantao law firm. The American author and journalist Horace Greeley, some 150 years ago, immortalized the phrase, "Go west, young man, go west." I am, alas, no longer a young man, and I have, in defiance of that instruction, chosen to go east. And given the theme of my address, it's entirely appropriate that I should do so, for the focus of the modern Olympics has switched to Asia. In this year, the Winter Games in Pyongyang, in 2020, the Summer Games in Tokyo, in 2022, the next installment of the Winter Games in Beijing. Beijing, which has already staged a highly successful Summer Games in 2008, which I attended in my capacity as an arbitrator for the Court of Arbitration for Sport, or CAS. And maybe we shall see the Games in Jakarta in 2032. There was some surprise in the international press when Beijing achieved a unique double of being selected to host both a Summer and a Winter Games. It had not previously been perceived as a city for all seasons. But when, under the auspices of my good friend, Professor Peter Goh, another speaker at this conference, I had the opportunity to visit the main location in the Hebei province only 3 weeks after the award was announced, I appreciated that it was indeed a well-established winter sports resort. I noted that early as it was, a start had been made on a superfast rail link between it and the main city and on the building of an Olympic village. Now, the title to my talk permits, if it does not oblige me, to deal with a variety of sporting ethical issues. But if time compels me, as it will, to omit some important matters, there will be copies of my full text available on request from the Guantao law firm, alas, in English only. Host city selection. The selection of a host city to stage the Olympic Games, and indeed other high-profile international sporting events, such as the FIFA World Cup, raises itself important ethical issues. An investigation into the bidding process for the Salt Lake City Winter Games in 2002 revealed that several members of the International Olympic Committee had received gifts from the organizing committee. These included payments of cash, political campaign donations, tuition assistance for the child of one member, and even expensive dental treatment for another. And in consequence, very strict rules were put in place for future bids as to what small and token gifts the IOC members could properly receive from bidding cities. As the Ethics Commissioner for the London 2012 Olympic bid, I had to advise Lord Coe, the bid leader, as to where the boundary between ethical and unethical ways of promoting the bid lay. And I'm happy to report that our bid escaped any criticism for breach of the rules. 9. Questions have still been raised as to whether the Senegalese businessman, Papa Massata Diak, son of Lamine Diak, the former president of the IAF, sought to influence with bribes the award of the 2020 Games to Tokyo. His name features in so many of the allegations of bidding scandals over the past decade, including for the Rio Summer Games of 2016, which I should add, in fairness, he strenuously denies. 11. Questions also remain unanswered about whether the award of the FIFA World Cup to Russia for this year and for Qatar 2022 was the product of an entirely fair process or had been in some way corrupted. 14. Governance issues. I am, however, on firmer ground than merely referring to unproven allegations when I say that the previous administration of FIFA, under the presidency of Sepp Blatter, contained a number of persons who have either admitted to or are still facing serious criminal charges. Mr. Blatter himself was banned by the FIFA's Ethics Committee from further involvement in the sport for 6 years for having made an improper payment to one of his potential rivals for the presidency. Still more recently, the General Secretary, Mr. Valka, Blatter's right-hand man, was banned for 10 years for a large number of ethical violations involving a scheme for improper resale of World Cup tickets, for taking sightseeing trips with his family at FIFA's expense, for selling television rights for the World Cup below market value, all done in expectation of electoral support for the members of the then administration, including himself and his patron, Mr. Blatter. And I hope you'll forgive me from quoting from one paragraph of the award which I drafted. The panel would only add that one of the more striking observations in his evidence was that there was a real world and there was a FIFA world. This assertion had particular resonance in the context of the extravagant travel expenses incurred by high-ranking FIFA officials during the so-called Blatter era, which, to the extent that they were luxuries rather than necessities, were unbecoming for an international governing body whose funds should more properly be spent to promote the sport which it governs. The cases of Mr. Blatter and his associates are the most notorious, but alas not the only examples in world sport of the distortion of the process by which senior officials of the international sport are selected. 18. The temptation to abuse his or her powers is often related to the length of the official's period in office. A recent decision of the Ethics Board of the IAF found a long-serving senior Kenyan officer to have improperly misused payments made by Nike, the global leader in the sale of sports clothing and shoes, to promote its commercial interest in Kenya, but which he used for his own personal benefit. To 19, selection. To revert to the Olympics, once the city for the Games has been chosen, attention switches to the selection of participants. These, of course, are primarily decisions for the national bodies, though as the exclusion of Russian athletes from the Pyongyang Games this year showed, the International Olympic Committee, which runs the Games, can choose to exclude even those whom the national body selects. For the most part, selection does not involve ethical issues. The established rules set out in the Olympic Charter are first that only national Olympic committees may submit entries for athletes to participate in the Olympic Games, and secondly, that entries must be based on a recommendation from the relevant national sports federation, whether it be table tennis, in which your country, of course, excels, or football, in which, I suspect for a moment only, given President Xi's ambition to make China a global football power, it does not. But added to that is an important principle of sports law, that national governing bodies must faithfully apply any published criteria for selection, and where they do not publish criteria for selection of athletes for the Games, they will have a large measure of discretion, but even then, they must, again, as a matter of sports law principle, not act arbitrarily, unreasonably, or unfairly. 25. There are two less unusual areas of selection which do involve ethical or semi-ethical issues. The first relates to circumstances where an athlete wishes to transfer allegiance from one country to another, and the athlete has genuinely severed links with his country of birth, but is prevented from competing for the country of which he's now a citizen for purely political reasons. In the Olympic Games in Sydney, several cases involve the refusal of the then government of Cuba to agree to a shortening of the normal 3-year period which has to elapse before a person who's acquired a fresh nationality can compete for the nation of which he or she is now a citizen. And in one such case, Cuba had deprived the sportsman in question, a canoeist, after his defection, of all the fundamental rights usually enjoyed by its citizens and made him effectively stateless for far more than 3 years. The CAS panel said this: the notion that Cuba in these circumstances should be in a position to prevent Mr. Perez from competing is offensive to two core principles of the Olympic Charter, namely that the interests of athletes are fundamental and that Olympic competition is among athletes, not countries. Forum shopping. 29. The second relates to the sporting equivalent of what lawyers call forum shopping, where an athlete wishes to transfer allegiance from one country to another only because it improves his or her chances of selection for a national team. Although, as the Perez case confirmed, in the Olympics, the contest other than in team games is between individuals, the reality is that individual successes are identified as national successes. Medal tables are regularly compiled to show which nation has achieved the greater numbers of gold, silver, and bronze medals. The People's Republic of China has, of course, in recent Summer Olympiads, often been in first place. For those tables, Yao Ming, the celebrated basketball star in a team sport, is treated no differently from Yu Jian, a star in individual sport, who famously won the short hurdles race at the Athens Olympics in 2004. But it offends against the sense of what is right and proper, that sportsmen or women, unlike members of the Chinese team, should compete under the flag of a nation to which they owe no true allegiance as mere mercenaries. 1/3 of the Turkish team at the recent European Athletics Championships in Berlin consisted of athletes imported from other countries. 32. At its recent Congress in Buenos Aires, the IF updated the rules to prevent a recurrence of any such situation. There is a minimum 3-year waiting period before an athlete may transfer to represent another member. There's the establishment of a review panel to make determinations on the credibility of applications for transfer. There is a need for the provision of evidence that countries are offering full citizenship and associated rights, and another provision that an athlete can transfer only once and that no transfers can take place before the age of 20. CAS's ad hoc panel. 33. Selection issues for national teams usually predate the opening of the Olympic Games and are decided in national courts or tribunals, or exceptionally in the Court of Arbitration for Sport, sitting in Lausanne, the Olympic city in Switzerland. However, for 10 days before the opening ceremony and until the closing ceremony, a so-called ad hoc panel of selected international arbitrators, 12 for summer, 9 for winter games, is the only body which can decide Olympic-related disputes. The country in which the host city is located will provide at least one of the arbitrators. In Beijing in 2008, 2 of the 12 were Chinese. 2016 was the 20th anniversary of the first ad hoc division of CAS at the Summer Games in Atlanta. Since then, there have been ad hoc panels present at all the successive Summer Games and indeed at all Winter Olympics, as well as, yet more recently, at the Asian Games in Jakarta and indeed at the Asian Beach Games. All this reflects the growing importance of this continent in the sporting world. What then are the main issues with which they have to deal? Field of play. Arbitral tribunals, and more so courts of law, will not interfere with officials' decisions as to whether the rules of any sport have been properly applied. I said in one of my decisions in the wake of the Athens Olympics of 2004, when the Korean gymnast was the victim of admitted mismarking for his performance on the penultimate apparatus in the men's all-round gymnastics final, finality is in this area all important, and rough justice may be all that sport can tolerate. But there is one exception, and that is where the official's decision is tainted by fraud or corruption. For mistake is one thing, fraud quite another. In the 2002 Olympics held in Salt Lake City, there were allegations that the pairs figure skating champion competition had been fixed. One of the judges, a French woman, was said to have inflated her vote for the Russian pair in the expectation that the favor would be returned by the Russian judge when the dance pairs competition, in which there was a strong French duo, took place a couple of days later. The controversy was resolved by the award of gold medals to two pairs, both the original Russian winners and the original Canadian runners-up. A stroke of good fortune to one of those two pairs, though we may never know which. Match or spot fixing. It's not only officials who can act corruptly. Sportsmen can do so too. They can fix matches, or without fixing matches, contrive that something happens in the course of a match, so-called spot fixing, which enables gamblers, who've of course been given advance notice of what is to occur, to make a very large fortune. A recent report commissioned by the International Tennis Federation showed how prevalent the practice was in that particular sport. 38, the right equipment. All sports have rules to regulate the clothing and equipment that can be used to prevent some unfair advantage for particular competitors. For example, in Sochi in 2014, there was an application to disqualify 3 of the French medal winners on the basis of a violation of the rules relating to ski suits that were set out in the International Freestyle Skating Competition rules. The application was, however, made out of time, so the merits never fell to be considered. The right degree of disability. Disability sports are governed by a very complex set of rules which identify the various categories of disability. These can be flouted by athletes, aided and abetted by coaches and team managers, who pretend to a greater degree of disability than they in fact suffer from, and so gain an unfair advantage over their honest competitors. The most blatant example occurred in the 2000 Summer Paralympics, where athletes from Spain competed and won the gold medal in the basketball intellectual disability competition, despite the fact that the majority of the Spanish team players had no intellectual disability at all. Discrimination. Most international sporting codes prohibit the kind of discrimination which is generally, if not universally, regarded as unacceptable, and mercifully, these rules are usually complied with. Sport, at any rate in relation between sports people themselves, tends on the whole to unite rather than to divide. But in a rare and ill-advised rather than deliberate breach of that code, a Brazilian athlete in the Beijing Olympics made and was punished for making a facial gesture which appeared to mimic what she thought to be the classic Oriental features. Doping. The major ethical issue in the field of international sport has for many years been the use of performance-enhancing drugs. You will no doubt know about the allegation of state-sponsored doping by Russia, which has resulted in the suspension of Russian athletes from international track and field competition unless they can show they were not caught up in a system. If they can show that, they can compete as so-called authorized neutral athletes. Before that, the major scandal in this area was the disqualification of the Canadian Ben Johnson, winner of the 100 meters at the Seoul Olympics in 1988, which has been described as the dirtiest race in history. And only one of the 8 finalists was never found in his career to have been guilty of anti-doping rules violations. In fact, doping issues which arise during the Olympics usually relate to offenses committed before they start. The reason is that unless the athlete admits the violation, there has to be analysis of 2 samples taken during tests, the so-called A and B sample, and the athlete is entitled to be present at the test of the B sample to ensure the analysis is properly carried out. So the process takes time. 44. Since 2004, the rules which impose penalties of ineligibility for the use of prohibited substances, for the most part those that are performance enhancing, are contained in the World Anti-Doping Code, which is applicable not only in the Olympics but more generally. The code has been revised twice and is being in the process of revision for a third time as the World Anti-Doping Authority seeks to ensure that the code is both firm but also fair. Key is the strict liability rule. The presence of a prohibited substance in an athlete's bodily fluids is itself an anti-doping rule violation, which results in the annulment of the athlete's results in any competition potentially affected. There is no need for the anti-doping authority to prove that the athlete intended to enhance performance, or even that he or she intended to take the substance. Intent of either kind or its absence is only relevant to sanction or to penalty. 47. If the athlete cannot prove lack of intention, the default position is that for a first offence, the period of ineligibility will be 4 years, unless he can show that he's guilty of no fault or no significant fault, in which case the period of ineligibility can be eliminated or reduced. Where it's an issue of reduction only, the CAS has laid down guidelines, including a list of the objective and subjective factors to be taken into account, so as to assist in achieving a broad consistency in the case law. But of course, all cases ultimately depend upon their particular facts. There are factors which may mitigate, and there are factors which may aggravate the penalty. A prompt admission of guilt or other cooperation with the anti-doping authorities can mitigate. Repeat offences can aggravate. Indeed, a second offence can result in a lifetime ban. The war on doping has been described as a contest between laboratories and lawyers. The accredited and honourable laboratories identify new substances produced by unethical chemists and supply the analytical results in particular cases which lead to charges of anti-doping rule violations. The lawyers sometimes seek to find flaws in those results or propose ingenious explanations for the presence of the prohibited substances in their client's body. Some are more or less credible, such as their drinks were spiked by a rival, or just as a foolish prank, or, as has now been accepted in no less than 3 CAS cases, that the substances, sometimes a recreational drug such as cocaine, has resulted from a transfer of saliva in the course of passionate kissing of their girlfriend or boyfriend. Other explanations are incredible. 53. I cannot leave this topic without noting that there have been cases where officials who ought to be enforcing the rules in the interests of clean, that's to say non-doped athletes, either conceal positive results of athletes in their own country, or in one notorious case, blackmailed an athlete, a female Russian marathon runner, to pay the officials substantial sums of money as the price for such concealment. 55. Gender issues. A new and troublesome ethical issue relates to the problems caused by intersex and transgender athletes. Sport has always recognized the need for separate competitions for men and for women, where the requirements for success of size, strength, and stamina favor men over women. Intersex athletes. But intersex athletes have the sexual characteristics of men and of women, and some female athletes are born with abnormally high concentrations of the male hormone testosterone. A set of rules laid down by the International Athletics Federation, which would prohibit a woman with more than a particular level of testosterone from competing in a woman's race unless she had treatment to reduce those levels, was suspended by CAS on the basis the scientific evidence was insufficient to justify them. Since then, further studies have been carried out, and a refined set of regulations will come into effect on 1st of November of this year, unless a fresh challenge succeeds. Most of the attention has been focused on a single athlete, the South African runner Caster Semenya. Her case and the IF's proposals has aroused high emotions. Various human rights bodies, including the United Nations Human Rights Commission, have loudly voiced concerns. It suggested the rules are actually discriminatory against women because no similar rules about abnormal testosterone levels apply to men, that the rules offend against female dignity and privacy, that it's unacceptable that any woman should be compelled to undergo some form of therapy as a precondition for participation in her sport, and it said that the science to justify the rules is actually flawed. I've been involved in providing advice on this issue to both the International Olympic Committee and the Athletics Federation over the years, so I must be careful in what I say by way of comment on it. I can, however, observe that while the previous rules were in force, Ms. Semenya's performances on the track significantly decreased. 61. Transgender. Transgender athletes present still more formidable problems. There are several countries whose laws allow someone who was born a man to identify himself as a woman and afterwards to be treated in law as a woman. But obviously, a person who remains biologically a man, even if legally a woman, cannot be permitted to compete in women's sporting events without making a nonsense of the competition. Usain Bolt might come out of retirement if he were allowed simply by saying that he identified himself as a woman to compete in women's events. And if that were so, he might be winning Olympic gold medals when he was 50 or 60 years old. Disability sport. No less sensitive ethical issues arise in connection with disability sports, in addition to those of which I spoke earlier. Although these have attracted in recent years much more spectator interest, there are nonetheless a small number of disabled athletes who wish to compete in ordinary competition with its greater reputation and rewards. The best known of these was the South African runner Oscar Pistorius. He was known as the Blade Runner because he ran on prosthetics after amputation of his legs below the knee. He competed in the London Olympics after he persuaded CAS that the IF had been unable to show that his blades gave him a competitive advantage over able-bodied athletes. Since then, the IF, whom I've advised, have changed the burden of proof to compel an athlete to show that he gained no further advantage from his artificial limbs. Level playing field 64. All these issues that I've discussed in your presence have a single objective, that competition in sport be fair, whether it's in terms of the choice of who governs the sport, of the choice of which venues are selected for global competition, and above all, in the way in which the games or sport are played. As Tom Murray, an acknowledged expert on sporting ethics, has written, at the heart of what we care about sport is the combination of natural talents, the dedication and discipline to perfect those talents, and the courage to test yourself against an external standard, be it your competitor, a measure of distance, or the height, or the clock. Now, in my paper, I have dealt after this with the issues of enforcement, of remedies, and of adjudication. But I must not eat into the next speaker's half hour. I have to Professor Peter Coe, who will deal expertly with those topics. So I must therefore conclude, I'm glad to note, just within the half hour that I've been allocated. Because I hope, this is at para 81, I hope I've convinced all of you, if I've done nothing else this afternoon during my address, that there is much work to be done for lawyers in the ever-growing field of sport. It would be pleasant to think that I might be present at Beijing in the Winter Olympics in 2022. I shall, after all, then be a mere youth, only 80 years old. But whether I watch it from the stands or via a screen, I'm confident that will be a huge success. Thank you very much.
接下来呢，我们邀请到了国际体育仲裁法庭 CAS 仲裁员、国际田联 IAAF 纪律审裁员、英国特许仲裁协会高级会员 Professor Peter Kang 为我们带来分享体育仲裁和纪律程序。掌声有请。
Now, for resolutions of sports dispute, we have to deal with 5 things. 1, disciplinary cases. 2, rules and regulations. 3, disciplinary process and internal disciplinary. And lastly, legal advice. This is a compromise. 我可以用英语发言 but my PP will be in Chinese. Okay? Now, national court in any common law countries, whether it is in England or in Singapore or in Canada, there is a reluctance to interfere in sports disciplinary matters. My quotations: the national courts in any common law countries regard sports problems, issues, as best resolved, if possible, within the sport. And they are very reluctant to interfere in the internal regulatory affairs of sport governing bodies. And this is a quotation from Michael Beloff's book. The 3rd edition is coming out, and I think he has to share some of his royalty with me for giving the publicity, you know. Now, another quotation from the book written by a member of his chambers in London. That is what he said. The same thing, basic, very basic principle. No punishment for the offense. The national courts in any common law countries regard sports problems as best resolved, if possible, within the sport and are reluctant to interfere in the internal regulatory affairs of sports governing bodies. Punishment. In other words, the penalties for infringements of sports regulations. The very basic principle is this: no punishments for the offense if the governing regulations, rules and regulations do not provide for such punishment. Conduct must not be contrary, inconsistent with the rules and regulations existing at the time of the alleged offense. For any amendments, any regulations, any changes, it must be brought to the immediate attention of the players involved. Now, what happens if there are new regulations, new rules and regulations? One thing must be very certain. Any amendments, changes, must be brought to the attention of its members and must be posted on the website of the governing body with notifications, can be published in the newsletters or by emails. And I would suggest that in the future, they must be published in WeChat, Weixin. Because right now, Michael, in China, everything is transacted over WeChat. So in addition to this, social media like WeChat must receive adequate exposure and publicity. You agree? Yes or no? How about the disciplinary process of national governing bodies? Now, the international governing bodies require national governing bodies to have its own sets of rules and regulations to deal with the particular game. Now, disputes within the sport can be settled internally by its own disciplinary process. Now, international federations, the regulations, the rules and regulations, there can be variations, but must be strictly followed by the national sports body. For example, in rugby, disciplinary process is governed by the International Rugby Board Regulations number 17. And all national bodies in all rugby playing countries have to comply with the rules and regulations established by the international body. Now, what are the major grounds for internal disciplinary proceeding by national governing bodies? What are they? One is what our earlier speaker, Mr. Michael Beloff, has mentioned before. Prohibitions of specific action, such as doping, misconduct on or off the field, and corruptions. Child or minor protections. Then jurisdictions or authority over eligibility process, conditions for participations, criteria for selections in international competitions, promotions or relegations of member clubs, especially in football. Now, this is a case cited in most of the sports law textbooks. This is a case arising from an athlete in Singapore, and was one instance where the national court did interfere. This is the case I'm talking about. The national court did interfere because this was a very well-known athlete who was sent to Japan for training, and he came back 2 weeks earlier, right? And because of this, he was suspended, and he applied successfully to the national court, and the national court did overrule the decisions of the National Athletics Body to suspend him for something that is not connected with the world of sports. This case was quoted in all the sports law textbooks. Ad hoc contracts. The existence of a contract which is implied by participations in a sports events and agreement by the athlete to participate in the particular sports. There is no need to have a formal written contract. Participations in that particular sport amounts to an implied contract. Now, what is this so different from proceedings in a court of law? In other words, I'm talking about disciplinary proceedings, disciplinary tribunal, how different it is from a national court. One, disciplinary bodies are not national courts, and they are not required to function like a court of law. That is correct. And they are not bound by the strict rules of procedure and evidence. Must not interpret the meaning of the rules and regulations as they're applying. However, there is a major principle. There must be the principles of fairness. Now, legal advice, this is very useful for sports lawyer, not only in China, but anywhere in the world. Legal advice can be given in disciplinary proceedings, and legal advice, written and oral, can be very useful in a variety of situations. One, and helping the national bodies in the drafting. Two, arranging for a procedure for the conduct to take place. And also the conduct of the disciplinary tribunal. And also to assist in helping challenges and appeal depending on the outcome of the tribunal decisions. Now, I've mentioned the book again, you know, Michael. This is what Michael Beloff say in his book. Achieving very good legal decisions, making the conduct of disciplinary proceedings is to appoint a lawyer. Emphasize, appoint a lawyer, such as from China, the sports lawyer, to chair the disciplinary panel. And this is from page 243, the second edition. And I was told that the second edition has already been translated into Chinese. I'm going to get a copy. Now, what are the unlawful conduct of disciplinary proceedings? One, you may have defective charges and a finding of guilt. For example, a charge of aspirin is not even a banned drug. Or there can be misapplications of the rules and regulations, finding an athlete of receiving an illegal payment when that person, that athlete himself, does not know that the payment was paid into his account. Bad faith. Banning a competitor in a motor racing in order to enable a rival competitor to participate. The other areas, and to us practicing in common law court, we always believe in one thing, natural justice. Natural justice, key factor in the administrations of justice, natural justice. Accused not accorded with fair hearing, no natural justice. And therefore, the decisions cannot be upheld. A member of the tribunal has an interest, financial interest, or otherwise in the outcome of the hearing. By imposing a sanctions or a penalty higher than the range of sanctions. For example, finding the athlete 10,000 where the regulation existing provide for a maximum of only 5,000. Now, this is the famous tennis star. He was banned for life. At the same time, he was $100,000. You cannot suspend him for life and then give him a financial penalty. So that was appealed to CAS. Then the life suspension was upheld, and rightfully, the fine was squashed. Any other questions? One thing I like about lecturing in China is that the students, the participants are very attentive. Okay? Anytime, if you disagree with me, you can raise your hand. Now, minors and penalties. It has always been held, and was held in one particular case, that it would be always governed by the law of contracts. The law of contracts, the general principles of law of contracts applies to situations involving minors in the world of sports. If the player benefited from the outcome of from the contract that will enable him to achieve fame and fortune, then the principles of the law of contracts would be applicable to the minor as well. Now, I will not talk about this because, Michael, you have already touched on this, on the Olympic Charter and WADC. That is briefly, any athletes banned for more than 6 months for a doping offense from taking part in the next Olympics. And there was a case decided on these issues. Now, swimmers from the PRC. But this was years ago, more than 20 years ago, right? That was a long time ago. They were positive, tested positive, and this was a case going to the CAS. Then, you asked me about the recently concluded Asian Games. China did extremely well, right? China won the maximum number of gold medals. There was not a single ethical issues arising from any of the Chinese athlete team. There were 2 instances, one involving Gao Fuqiu from Sri Lanka. Another one was in relation to 4 national basketball players from one country because they were caught going to a red light area. They were sent back. But not a single instant ethical issues involving national team from China. And this has not been the case over the last 20 years. Now, this is different disciplinary procedures over the same sport. We talk about the soccer governed by the National Sports Associations, FA. Then you have the jurisdictions of, sometimes they have maybe under FA League or the Football League. Now, misconduct and breach of soccer is dealt with by the football associations. But breach of the rules of the league can be administered and dealt with by the league. Lastly, appeals to the CAS. Many of the international sports federations do provide for appeals against decisions to the Court of Arbitrations for Sports, or CAS in Lausanne. Now, CAS has jurisdictions within its rules and regulations when both parties voluntarily submit to its jurisdictions. I will conclude to say one thing. Say some words in Chinese. 女士们、先生们，我今天非常荣幸你给我这个机会跟你们分享体育纠纷的问题。Any questions? You can ask me. How am I doing for time? I'm doing well. So, of course you can.
I speak Chinese 因为那个兴奋剂嘛，我看那个，我想问一下，就说，现在因为中国政府一直在抓那个反兴奋剂这个事情嘛，而且我看这几年做的还不错。那我想你站在英国那边，就是那个角度来说，国际上角度来说，看中国的那个反兴奋剂这个力度做的怎么样？
反兴奋剂是吗？OK， 第一，你看这20年没有任何中国国家代表有任何道德的问题，没有啊。 这样子呢，就是中国的反兴奋剂的规则做得非常好，这是我个人的意见。我个人的意见，这是不是几年的事情？20多年没有，过去有，但是已经是历史了，好多年了。我觉得你们的反兴奋剂的规则，还有呢，处理得非常好，管理得非常好。Any more questions? Yes.
谢谢 Peter 教授。我想有一个问题想问一下，就关于这个赛场上的政治敏感动作的这个处罚的机制。可能您也注意到，在俄罗斯世界杯上，有一场比赛，有2个球队，其中有一个球队的几个队员，您知道瑞士对塞尔维亚那场比赛，他们做出了一个政治敏感动作。我不太清楚这个问题适合问您还是问Mr. Michael Belov。
哦，您是讲那个足球操纵的问题吗？
对，没有政治敏感动作，在足球比赛当中有一些政治敏感动作。在这个俄罗斯世界杯曾经小组赛的时候，瑞士对塞尔维亚的比赛当中，瑞士球员当中有3个球员是科索沃祖籍，他们在进球的时候做出了几个这个动作非常敏感，这个塞尔维亚表示强烈抗议。但实际上就处罚的结果，其实从我个人判断，因为这个完全是个人的一个主观的一个判断。处罚结果比较轻，他们只是罚款，并没有停赛。因为世界杯比赛其实要停赛，对相关的球队影响可能会很显著。我想我的问题实际上是这样，就是这个处罚的决定肯定是FIFA去做，但是FIFA什么部门去做？它是根据什么标准去做这个处罚的决定？而且处罚的内容是罚款还是停赛还是什么？这个是依据是什么？所以这个问题我不太清楚是问您还是问Mr. Michael Belov。Could
I translate? He's asking about the penalties arising from soccer games. You know, that I can say one thing. 我知道，不是只是在这个在俄罗斯，在中国足球俱乐部有非常多的法律问题，不是只跟中国，全球是一样。你知道，从操纵的案子只是在欧洲。那个数目多少吗？是 0.5 trillion，0.5 trillion 是13个零啊。
我这个问题不只是 match fix， 这是 political sensitiveness。
对 ，we do not as a lawyer in CAS, we're not qualified to discuss on political sensitivity unless Michael would like to discuss. But anything to do with political sensitivity, we best leave it to the politicians. But for rules and regulations, for sports law, yes, 道德的问题。
But I know the focus with Michael Belov is focusing on the ethical issues in the sports. So my question is on the political sensitivity on the ground. So this is my point.
You want to answer his questions on political sensitivity, on ethical issues? I will not comment.
Is there any difference between two?
Yeah,
on
please.
Yeah.
Yeah.
I think he says his questions are not politically sensitive. He's talking about foul play, for example, in football.
Mm-hmm.
And I just, 2 very short points. One is, and neither of us have mentioned this, there's a increasing use of technology, especially in football, like tennis, in order to assist the officials in determining whether or not someone, for example, in football was deliberately dived in order to try to get a penalty at the expense of the other side. That's the first point. So technology is there to help the officials. Secondly, I think it is true. I think diving in football, that's to say pretending that you have been knocked over and so on in order to gain a penalty, is a very serious offence. And I suspect that the penalties are not really sufficient to deter persons. And indeed, a well-known Brazilian sports lawyer actually said that in Latin America, in South America, the tradition was to try to deceive the referee. In fact, that was, they thought, part of the game. I certainly would not think that was part of the game, and I hope that very few, if any, of you in the audience think so.
Yeah, I agree with you. I endorse. 他的中文进步了。The question was in Chinese, but he could understand everything, even without the translations. So anyway, any other questions? Because we have limited time. Yes.
这是我们最后一个问题。
最后 This is what I like in a court of law, have interrelations. Yes.
就是想跟第一个问题一样，就是您提到在中国这个反兴奋剂还有就是体育道德准则这个问题做得已经很好了，然后您觉得还有什么不足的地方需要改进，进一步的改进，存在哪些还存在的道德准则方面的问题？
OK， 我可以告诉你，第一呢，哪一种运动是最腐败？第一是全球是足球，第二呢是板球，第三呢是赛马，第四呢是网球，第五呢是橄榄球。但是你看这20年没有兴奋剂法律的问题，也没有我知道在很多地方包括很多地方亚洲的国家，足球操纵、腐败，还有一些法律的问题，肯定是有的 ，right? Isn't it the case about in the minor league, and which was published recently, 1 out of every 10 games in the world has been fixed. Yes, see? So you can see 全世界
And the important point that is made there is that whereas the sporting authorities will be very careful, let us say, with the World Cup or some major international match, obviously in the minor leagues, they haven't got enough resources to police those. And indeed, it's in the minor leagues where this kind of thing happens, and the gambling industry thrives on that. That's a very, very big problem now in international sport. The former president of the International Olympic Committee, Jack Rogger, thought that corruption was more important even than doping now, and I tend to agree with him.
Yes， 在印度板球非常腐败，有超过1万家公司。
这样的，我试着
好了
，excuse me， 我是可以试着回答你们这2个兴奋剂的事情，好吧？因为讲到中国的这个兴奋剂呢，我稍微介绍，因为从一个肯定的角度讲呢，中国这个反兴奋剂运动呢，它是朝着一个非常积极的方面去发展的，知道过往多少年，我们大家知道了以前马家军事件啊等等这一系列都已经变化很大了，包括社会主义阵营原来东德的这个变化都很大，对不对？但是呢，就是说在这么好的一个状态之下，大家也知道前段时间08年奥运会还是现在倒查的时候还出了一些问题哈，就是说包括这个最知道大家就是举重队出了问题是吧？这是亚运会呢，举重队中国就没有去参加，对，但最后呢，现在什么结论我们现在也不是很清楚是吧？而且还有一个很不好的事情呢，就是国际层面就出了这个俄罗斯事件，从这个田径队集体竞赛到里约奥运会到平昌冬奥会竞赛，对不对？但后来呢，他也做了例外规则，就是搞了这种个人清洁运动员啊等等自证逆向自证，就是说我证明自己是清白的，我通过时间点啊没有这种做坏事的时间啊排除掉，这样呢以这种中立身份，那不能以俄罗斯这个国家身份去参加这个东西。这个当然就是刚才这位问的，就是说有什么新特点，有组织化的，是吧？又回到了那种非常不好的一种状态。那现在比方说从威达或者从他们也在做这些工作，就是说我规则上怎么在制定，然后呢就包括中国呢也反省一下，哎，那现在俄罗斯这个兴奋剂检测中心出了问题，那我们以后怎么处理？这个体育协会呢，跟单项联合会啊怎么处理关系？跟 CAS 之间怎么去处理关系？他这个呢也重新也要再考虑这些问题，但总的趋势是一定就是反兴奋剂的。另外呢还有一个问题是什么呢？现在这个反兴奋剂呢，一个我们都是天天喊打，但实际上大家还关心一个问题，可能大家要知道一下，因为这几位专家他们很清楚，反兴奋剂的过程当中呢，他采取的是严格责任。这个严格责任就是一发现就有问题就要处罚，一处罚就禁赛，一禁赛这个运动员就基本上就完了，对不对？那这个时候呢，就面临着什么？就是哎， 维护这种体育这种纯净啊和这种运动员权益之间保障这个问题，他也在那个。你看，这是俄罗斯事件，他这么有组织化了，最后还是他打了例外规则，就是个人清洁这个规则。我大概就是总的方向是
谢谢
这样
谢谢你，
但是不断
谢谢你，谢谢
出现
你。哦，你
新的特点。
讲这样是反兴奋剂哦，赛马球，我是很喜欢马球，不是只是人，还有马。兴奋剂的规则不是只是包括那些运动员，也包括那些马。所以我今天非常荣幸有那么多人给我问题，这就是我非常喜欢这种反应。谢谢，谢谢你呢？谢谢你们。
好，我们再次感谢 Professor Peter Kang 给我们带来的分享啊！大家如果还有其他的疑问的话，我们可以在私底下再进行更深一步的了解和探讨。接下来，让我们用热烈的掌声欢迎来自加拿大反兴奋剂审查委员会成员 Mr. J.J. McIntyre 为我们带来国际体育赛事的商事赞助问题，有请。
Thank you. Unlike Peter, I can't address you in Mandarin at all. I would, I'm sure, harm the ears of everyone here if I tried. So my Mandarin is very bad. I apologize for that. My topic today has to do with sponsorship of international sporting events, mostly in relation to the Olympics as well as in relation to the FIFA World Cup. I'm sure you're all familiar with those events. As you know, holding those events not only brings international visitors to the host countries, it attracts literally billions of eyeballs to the events through the media, so that there is great potential for marketing opportunities to those companies that sponsor those sporting events. And because there's so much money involved, it's very important that those companies know exactly what it is that they get and protect their sponsorship rights. Now, if I can just move on a bit. Okay, that's not working. What do I do? That way. Okay. Sponsorship is just one of the commercial rights to be distinguished from other commercial rights common to world sporting events. We include in sponsorship many different aspects. Now, I've set out here a definition that is actually contained or was contained in the Asia Football Confederation Marketing and Media Regulations for the 2018 FIFA World Cup Russia. This was for the Asian qualifiers round, and this was what they set out in terms of definition of commercial rights, as including the advertising rights, media rights, concession rights, hospitality rights, image rights, intellectual property rights. You can read it. And you can see that it's quite a list. And the reason why that becomes important is because as companies obtain exclusivity of marketing opportunities, they have to know exactly what it is that they've contracted for. Sponsorship is really governed by contract more than anything else. It's a contract between the International Olympic Committee, or FIFA, with the companies that agree to provide levels of sponsorship. And what they're doing is they're paying for exclusivity of opportunities. So it's, broadly speaking, it can also be an agreement between an athlete and a sports organization and a corporation, where the corporation is granted certain rights to endorsement, the intellectual property or imagery and marketing opportunities in exchange either for financial support or contributions in kind of goods and services. Contributions in kind of products or services are those products and services that are considered necessary for the participation in or hosting of the event. They must be goods or services provided by a sponsor that directly affect the specific event budget. So in other words, if they weren't being provided by an athlete or a sporting organization would have to pay for it if those products weren't being provided by a sponsor. So for example, I mean, you all are aware of the timing events that take place, International Olympics, for example. Those are usually sponsored by a timing organization or a timing company, and they provide for the exclusive opportunity to be known as the exclusive supplier. Now I've set out here, this comes from the Olympic Committee, or this shows the marketing revenues that they obtain for sponsorship broken down to between broadcast opportunities, so that would include the media and television, internet rights. Sponsorship, broadly speaking, includes everything else. Ticketing is a very small portion of the amount of money that actually comes into the Olympics. It's only 5%. And licensing refers to the products that people take away, the T-shirts, the things of that nature that people buy or might be inclined to buy at an event. As I set out, for the Olympics, it's the exclusive sponsorship opportunities that are being sold. There are currently 13 worldwide sponsors at the top, which stands for the Olympic partner level of Olympic sponsorship. The top program operates on a 4-year cycle, so each partner is committed to and has worldwide rights, whether they use them or not, for summer and winter Olympics. And the top program provides each worldwide Olympic partner with exclusive global marketing rights and opportunities within a designated product or service category. Now, the way this came about is because most of you are probably too young to remember this, but Peter Ueberroth, well, I know Michael remembers this. Peter Ueberroth, back in the 1984 Olympics in Los Angeles, came up with the concept that if you reduce the number of sponsors or the availability of sponsorship opportunities, you could increase the price that you would get and by providing for exclusivity of opportunities. And that has been basically the strategy that these worldwide events have adopted. They've gone for less sponsors, more money. That's the way it works. Now this comes from the internet, so of course it's reliable. It's guessed that the cost of being a top sponsor is in the range of about $25 million US a year. At the next level down in the Olympic Games domestic sponsorship program, it's managed by the organizing committee for the Olympic Games, so the host country, under the direction of the International Olympic Committee. The Olympic Games domestic sponsorship program grants marketing rights only within the host country or territory. So what we have, and this is for the Tokyo Games that are coming up, 2020, you have at the top level exclusive the worldwide Olympic partners. Then Tokyo Sponsorship Committee has established gold partners, official partners, and official supporters. And I'm assuming that Beijing has done the same or is doing the same for the Winter Olympics. Gold level sponsors for Tokyo have agreed to pay 15 billion, this would be yen, or 119 million US dollars, 110 million euros for their sponsorship rights. Official partners pay 6 billion yen, 51 million US dollars, or 44 million euros for theirs, and the lowest tier pay 3 billion yen for their package of rights. Now, the Tokyo 2020 Olympic Games have raised over US $2.8 billion from local sponsors alone. In order to increase the pool of sponsorship opportunity, they've had to be creative as to what constitutes an exclusive category of product or service. Now, I haven't set out here all of those companies that have agreed to be involved, but essentially you have companies that you would normally consider competitors all of a sudden being considered exclusive suppliers or exclusive providers in certain categories that are hived out from those of the top program or the program just above it. For the World Cup has gone this is FIFA World Cup, has gone a slightly different route. The top level is to be a FIFA partner. Number of partners is limited to 8. And being a FIFA partner allows the sponsor to advertise their association not only at the World Cup, but at the other World Championship events and on a worldwide basis. Next level down is to be a World Cup sponsor. World Cup sponsors have rights to the FIFA Federation Cup, FIFA World Cup on a global basis. They're also entitled to ticketing and hospitality offers for those events. And the last tier is that of a regional supporter. There are 4 companies in the 5 global continent regions to promote an association with the World Cup only within their region. So what it works out to is, I should have left you that opportunity to read before moving on. And I should say that I've prepared a paper that is entirely in English, as well as these slides, and I hope that they're also available from the Guantao law firm. And perhaps if you can email them, they will provide you with both, or one or both, whatever you wish. But this is essentially the way the FIFA World Cup sponsorship strategy works. So they've divided up into the continents where football is played, sponsorship opportunities to regional supporters. Now, after the scandals that were taking place at FIFA World Cup, this led to a problem, of course, with the 2018 FIFA World Cup in terms of getting enough sponsors that were willing to come on board for Russia. So as a result of that, that opened up the door to many new Chinese companies to come in and to obtain worldwide exposure and rights in terms of being recognized as sponsors of the World Cup. Allegedly, again from the internet, the cost of being a FIFA partner is approximately 65 million euros annually. The cost of being a World Cup sponsor is 10 million euros to 30 million, and the cost of being a regional supporter, that's just not publicly available. And they have very few regional supporters for the 2018 Russia Games. Now, why is it important to know what sponsorship rights have been acquired? That's the reason. Money. Those companies have spent a lot of money for the opportunities. They want to make sure that they're getting what it is that they bargained for. That leads me to really the most interesting aspect in terms of sponsorship, and this has to do with ambush marketing. Given the amount of the investment of sponsors expected or demanded from the companies for the right to be associated with these world events, the most significant issue is ambush marketing. Now, it refers to the practice of aligning a brand with a particular event, and not necessarily in sports, or just in sports, so this would also apply to esports probably as well, without having paid to become an official sponsor. Ambush marketing devalues the commercial exclusivity that the companies have paid for and the prestige of the official marks, which are reserved for those who pay for it. So there are various forms of direct ambush marketing that I'm going to comment on. One is predatory ambushing. That's making it appear that a company is an official sponsor when it isn't, such as buying up airtime, media time when the event is taking place. Now, as a result of this, rules have changed over time because as ambush marketers have succeeded at various games, they bring in new rules to make sure that that doesn't happen again. So the ambush marketers find another way of getting their message across. Second category of ambush marketing is property or trademark infringement. Typically for the Olympics, for example, laws are passed. It's a requirement if you're granted the rights to hold an Olympics. So it prohibits the use, unauthorized use of trademarks such as the word Olympics, gold, silver, bronze, etc. by local businesses. And of course, that means that the Olympic police, if you can call them that, send out letters to all those Greek companies that run restaurants in the various venues where the Olympics are being held and try to get them to change their name, because a name that they've had for years and has nothing to do with the Olympics is all of a sudden now owned, or the property rights to them is now owned by the local committee. There's also ambushing by degree. This is when an official sponsor infringes on another sponsor's rights. An example of that would be if one company paid for the right to provide merchandising to an event, and a company that was already an official sponsor in another category comes in and starts to distribute their own merchandise at the event. And of course, that creates some bad feelings. And this might be an area where, when you're looking at what laws might be needed in order to protect the rights and of these sporting events, that some sort of provision is made for protection, or at least a dispute resolution mechanism where two sponsors actually have a dispute with each other. It would be a good area for arbitration, in fact. Lastly, the area I want to deal with is coattail ambushing. This is gaining exposure for a company's product through sponsorship of an individual athlete or a related event. And I've set out some examples in here. This is from the London 2012 Games. And what you see in that picture, if you look at the bottom of the page, is you'll notice that all of the athletes seem to be wearing these green-colored shoes that were made by Nike. Nike was not an official sponsor. Nike, however, were very successful in getting their equipment worn by athletes, and in fact, many of their athletes at those games won gold medals or medaled in the events. And of course, Nike was trading on, or made sure that they were getting the exposure as a result of that, when the official sponsor was Adidas at the time. This is another example. This comes, you'll recognize the logo as being that of Nike. This is actually Michael Johnson from the 1996 Atlanta Summer Games. Michael Johnson was competing in the 200-meter event. The official sponsor for the supplier for the event at that time was Reebok. Nike went out and developed these golden shoes that they had specially made for Michael Johnson, got him to wear them. He won the event. They got all the publicity, and Reebok were left without, did I say, yeah, that is Nike, isn't it? It was a Puma. Well, the next one that I have is also from the 1996 Games. This is Linford Christie. Most of you are too younger to know who he is. He was also an 100-meter runner. He won the 1992 100-meter event in Barcelona Olympics. And he was one of the people that was being interviewed prior to the event in 1996. And what he did was he wore these special contact lenses. The contact lenses, I don't know if you can tell, have the Puma logo on them. And as a result of that, this photograph was played everywhere and throughout the media and throughout the world. And this was before the event, because Donovan Bailey of Canada won the 100 meters at that event, at those Olympics. But Reebok was upset, of course, by this. But that's another example of clever marketing on the part of Puma at the time. Now, this is another example, Puma. This is from the 2016 Summer Olympics in Rio de Janeiro. You might recognize Usain Bolt. He's now won his third consecutive 100-meter event. And what he did after, this was a situation where Puma turned the tables on the official sponsor. They developed golden shoes with the Puma logo and provided them to Usain Bolt. who was being paid by them $10 million a year for sponsorship opportunities. Now, what he did after winning the 100-meter event was he took off his shoes and he paraded around the stadium like this, raising his shoes in the air and giving $10 million worth of exposure to Puma for the event. Now, as a result of that, there have been some tightening up of the rules. There was actually, I will deal with it in a second, a certain rule of the Olympics. What is interesting about this is, as a result probably of what he did, he was also competing in the 200-meter event. He wore different shoes. He won the event again, and he did not parade around the stadium. So one suspects that the Olympic police, or there was an Olympic crackdown on Usain Bolt at the time. Of course, they're not going to take away his medal. He was too big a star for them to do that. Because companies such as Nike and Puma have been so clever with their ambush marketing campaigns, and sometimes Nike is actually an official sponsor as well. So the sporting organizations have responded with more and more regulations to combat and prevent ambush marketing. Since there's no contract between the non-sponsoring companies and the IOC or FIFA, in order to protect their official sponsors, they try to do it through policing the athletes themselves. The way they do this is Rule 40 of the Olympic Charter. To participate in the Olympic Games, a competitor, a team official, or other team personnel must respect and comply with the Olympic Charter, the World Anti-Doping Code, including the conditions of participation established by the IOC, as well as the rules of the relevant international federation as approved by the IOC. Now, there's a bylaw to Rule 40. It says, except as permitted by the IOC Executive Board, no competitor, team official, or other team personnel who participates in the Olympic Games may allow his person, name, picture, or sports performance to be used for advertising purposes during the Olympic Games. So what happens if they do? Rule 50 steps in. Again, except as may be authorized by the IOC Executive Board, no form of advertising or other publicity shall be allowed. And that means under the bylaw, no form of publicity or propaganda, commercial or otherwise, may appear on persons, on sportswear, accessories, or more generally on any article of clothing or equipment whatsoever worn by all or used by all competitors. And this would include all team officials. And any violation of the bylaw may result in disqualification of the person. They're not going to do that for someone like Usain Bolt or the delegation concerned. Disqualification of the athlete or withdrawal of accreditation isn't the only possible sanction. In addition, Rule 59 of the Olympic Charter provides, among other things, for temporary or permanent ineligibility or exclusion for the Olympic Games. And these athletes, they spend their entire lives working up to being able to compete for their countries at these events. This is a big potential hammer in the event that they breach. FIFA also has established media and marketing regulations and equipment regulations for equipment used in the World Cup. Now, in the recent World Cup, 2018, the football associations of both England and Sweden were fined 70,000 Swiss francs as a result of players from both countries breaching those provisions by wearing on the outside of their official Nike-supported socks, ankle support socks. I had to look up what they were because I didn't even know what they were. They essentially, if you're an athlete competing in certain events where you're required or need to tape up your ankles because you have problems with your feet, then that's what those ankle support socks are for. They replace tape. Now, the fines were imposed after the players on both teams were warned, but they went ahead anyway. And as a result of that, and here's one of them, I don't know if you can see this, but at the bottom of the page in the three, I don't even know whose logo that is, but those are the ankle-supported socks. That is the breach that caused fines to be imposed against those World Cup teams. Well, Finally, a word of caution regarding sponsorship of individual athletes. And what is the impact on a company's brand from being associated with an athlete that turns out to be a cheat? Does everyone recognize this person? Lance Armstrong. He's the one that allegedly won 7 consecutive Tour de France's, only to find out or be exposed and admitted himself to having been a cheat and doping throughout. So perhaps athletes' sponsorship contracts should include a provision for liquidated damages. That's in the event of the athlete being caught out to be a cheat. It avoids the necessity of going to court in order to prove what the amount of damages are that have been suffered by a sponsor. As well as with any commercial contract, I would suggest an agreement to arbitrate the dispute should be strongly considered. That would go for just about any commercial contract. And those conclude my remarks. Thank you.
最后，让我们有请北京关涛中贸厦门律师事务所执行合伙人、福建省律师协会“一带一路”法律专业委员会副主任安寿志先生为我们带来大型赛事及俱乐部运营法律问题主题演讲。掌声欢迎！
大家好，因为时间已经拖延半个小时了，所以我尽快大概10来分钟把它搞完。然后接下来一个圆桌会议。首先谢谢大家能够参加，坚持到这么晚了哈，确实谢谢大家。那我觉得说，这个大型赛事和俱乐部运营，其实这个范围很广，我主要是从这个一些案例的角度来阐述一些方面，或者大家需要注意的一些问题。那我就是2部分，会很快。大型赛事其实大家也知道，就是反正很大很大的赛事是吧？比如说厦门马拉松这种赛事算大型赛事吧。不过现在的赛事除了以前我们感觉是什么亚运会、奥运会啊，现在其实这种民间的赛事也蛮多了，有的也上几百人啊，上千人啊，这样一些规模，所以这种赛事是越来越多了，然后它的风险也会多。它的风险就是说参与的各方面呢，人员呢，或者是这个方方面面的问题也会产生出来。那我觉得就是说这个案例在厦门哈，还有我们有一个就是说这个马拉松也是首例的，就是在我们大型的赛事里面的一个比较典型的一个案例。是在16年的时候，是咱们一个半马的过程有一个替代者，就是说用别人的号去跑，然后就是猝死了。这个就是后来协商不成的话，通过法院的方式来解决，他是要索赔123万元。那这个案件呢是一个很重要的一个问题，就是说他这个赛事运营方有没有过错，然后这个跑步者猝死他这个死亡之间有没有因果关系？那这个在后面通过了1审、2审的话，法院是认为，1审、2审都认为是赛事方是没有过错，不应承担责任。然后它是从技术方面来解决，就是说一个因果关系上面的一个原因力，还有一个可预见性。他认为是就是说这个过错是通过一个预见性，或者说一个来进行分析。那这样在本案当中，他们认为就是说这个按一般的常识，就正常人参加这个非专业的这个全中性的马拉松的话，这个概率是比较低的。就是一般我们的正常的运动啊、准备啊，或者说因为不是一个竞技运动，所以他在这种情况下面，就是说这个当事人呢在年龄啊、身体啊各方面都 都不存在不适合跑的一个情况。而且很重要的一点就是运营方呢，对于这个他跑步也没有说一定有成绩的要求啊、强度的要求啊，这样一个情况，认为就是之前是法院是认为是没有预见性的，所以说是认为这个之间不存在这个法律上的一个因果关系。因果关系根据我们那个侵权责任法第37条的话，认为是宾馆、商场啊这些娱乐场所啊，这种公共场合这些管理人，其实在本案当中他尽到了一个安全保障的义务，就是说他这个赛事方他的义务是一个安全保障的义务，所以在本案当中呢，他认为是已经履行到了一个安全保障的义务，所以说是驳回了这个请求。那这里面有一个问题，也可以有一个比较大家注意的问题，就是说，这一点是给大家提一个醒，就是这个李某违规这个转让参赛，这个运营方呢，在报名啊、领取参赛包啊、检录啊，以及这个参赛过程当中呢，有没有发现这个人？跟马拉松不一样，它有很多人，3-4万人或者更多的人，可能他很短的时间，他没有办法来进行一一的核对。但这里面也是提了一个醒，法院在一定程度上面说，可能以后也会存在一个疏忽，或者说以后对赛事方提出更严格的要求，你在这方面要做一些一些更谨慎的一些方面来保障这种疏忽的出现。所以在这个里面，我们认为就是说，在这个特别大型的赛事的时候，从这个案例里面得到一些启示，就是说，这个告知的义务，你在赛前呢也明确的去告诉他们一些可能造成的一些伤害啊、一些损害啊、一些可能存在的一些风险。就像我们现在有一个客户做这个减肥，就一个像一个全国性的一个赛事。那我们也告诉他，或者说那些现在很多户外的运营、户外的活动，那我们告诉他 ，OK， 要提示这些参赛人员，你有什么样可能什么风险、什么风险、什么风险、什么风险，你也注意这方面的一些风险，或者就是你有一个告知的义务。第二个预防的义务，你也采取一些严格的一些措施、安全保护措施，对他的参赛资格啊、沿途一些供给啊、保障啊。全程的一个交通的一些监控啊，还有很重要的一点是救助义务，就是在意外发生的时候，你必须及时救助，防止损害进一步扩大。因为这一块像下马这一块其实做得蛮好的，他就是说每50米还是100米就有一个就救护医生救护人员，就是他保证好像3分钟就能到现场能这样一个情况，所以这个当时都做得很好。所以这些情况，如果你没有这个的话，可能就很麻烦了，就是说你没有人在现场。那这个有一个就是像那个前段时间有一个是厦门也是那个水上运动皮划艇组织一拨人去搞这个，结果那天风浪很大，挺翻的，他没有这个救生的设备，就后来就报警了。那这个是那个是还蛮幸运的，就是那些人还没被淹死，都捞回来了。所以说如果说没捞回来的话，可能就你这个救生的设备就不到位。组织这个活动可能就要承担的这个责任了，所以在我们赛事里面，这里面的一些其实这些预防的、救助的这些要求，其实是需要蛮高的，或者需要一定要充分的考虑。到后面那个人道关怀和这个保险的话，只是一个风险转移的问题，或者说一个处理的问题。但前面3项我觉得是蛮重要的一个问题，大家以后做赛事，现在国内赛事越来越多。像我们去年马拉松全国是1384场，去年就是我们2017年各个地方各个省市是1384场，在5月14号是有4月15号是吧？4月15号那一天有54场马拉松全国，那这样的话，这是里面的一些风险呢，这些赛事可能大家也充分的去注意到这个。第二个里面赛事里面就比较重要的，现在就是说那个转播的问题，这个讲的是蛮新鲜热辣的，就是刚刚结束的这个俄罗斯那个世界杯，这个是第一个，就是说我们国内不是通过很多新媒体啊，这些这些直播啊、主播啊这样一个方式，再就是说我们在6月 20几号就开始这个世界杯，然后28号的时候，这个咪咕公司就以这个新某公司，它有没有授权，它在直播间上面，它的直播平台，在直播这个2018世界杯的这个赛事，分流了这样一些流量，损害了这个权益。这样其实杭州中院很快了，就是说去做以后，在6月28号马上又做出来一个行为保全，就立即在这个案件里面就要求他立即禁止这个公司来进行平台直播和点播这个世界杯赛事的不正当竞争行为。在这个案件里面呢，这个咪咕公司是认为就是被告在未经授权的情况下面擅自直播，因为咪咕是获得了央视的这个授权的，但是这个被告就是没有获得授权，擅自转播和直播，认为侵害这样一个权益。那被告认为呢，我这个就是我的主播和粉丝之间的互动，现在好多什么多少间房、6间房啊，在什么平台，这个平台那个平台，好多就是主播我有粉丝互动啊，就是这些东西，他说不存在一个信任关系。但是法院呢认为就是说，他这个还是违反了这个城市信用原则和公认的商业道德，这个蛮有意思的。城市信用原则和公认的商业道德，直接损害了这个体育赛事节目授权许可的一个正常的这样一个秩序，也就破坏了这个咪咕根据这个授权获得市场竞争优势，认为它是构成了不正当竞争，所以就准许了这个保全，另外马上停止。那么这个效果是挺好的，法院的这个裁定一出来以后，哈，就马上就这个上面就没有转播和这个直播了，对，而且动作也很快，在6月18号就做出来了。所以这个其实因为你这个赛事完了以后就没意义了，是吧？这个赛事整来就只有20来天，如果所以他这个就马上这个是也最新的，就是说我们赛事里面，一些大型的赛事，包括现在国内那些，我们别说那个央视那些，或者说中超或者什么，现在很多民营企业自主的一些品牌 IP 也慢慢也有这个转播的价值了。包括像现在国内那些什么跆拳呐、什么武林大赛，或者说那个什么踢王爵啊什么的，那他们慢慢也开始很多去转播这些东西，所以这个里面有这样的一些转播啊的一些问题。但是这里面有一个问题，就是说它是提出这里面其实是很重要一个问题，就是说，你看我们注意到它是以不正当竞争来进行这个起诉的，它不是以这个侵犯著作权。因为侵犯著作权有一个案件呢，是在2018年3月份刚刚做出来的，今年3月份，新浪诉凤凰这个侵犯著作权，那个也是在这个你看这个往后面拉，就是说这个案件里面认为，对于体育赛事的直播是不构成作品的，就我们著作权下面必须是作品。但是你这个直播这个画面是不构成作品的，所以通过这个侵犯他的著作权是没法得到保护的，所以只能通过不正当竞争。我们在早期的话，这些案例都通过这个著作权来维护，但是著作权在里面有就是它的认定会比较严格，有创新呐、有什么一些东西啊，所以他们认为你这个直播的画面或者那个闭幕开幕式的画面是不构成一个作品。这样这个东西，所以现在比较多的是以不正当竞争这个方法方式来做，而这个案件也是一样的，就是说斗鱼网也是通过一个当时是亚洲邀请赛2015这个DOTA，它也是以不正当竞争来提起这个的，当然这个也是认为斗鱼网是违反了这个不正当竞争的原则。这个就是我们认为就是说。在这个商业转播或者持权转播商发现这些的话，我们认为是应该立即的进行财产保全啊，那个证据保全，进行公证啊，进行什么的，因为这个东西它一删掉一下就没有了，或者说它就立即的去进行这个保全，然后这个还有做行为保全，然后马上申请这个向法院申请这个保全申请，之后再考虑起诉的问题。第二个呢，就是说我们。觉得目前在著作权的立法方面的话还是不太完善，可能也需要考虑扩大这个转播权的一个范围，把它放在这个网络。现在网络啊新媒体突飞猛进，现在说微信网络才是主流媒体，是吧？所以说这个里面应该是进行立法的一个呼吁，增加列举一些 作品的种类，这样一个情况。但是目前这个还没有啊，这个是呼吁立法，在我们13届刚刚出来的那个立法规划，全国人大的没有包括这个知识产权的这块的修改，所以现在目前的话还是以不正当竞争会好一些。啊，这个问题比较敏感，但是我觉得在今天都没提，我也想跟大家提一下，就是前2天那个，我不代表立场哈，只是说你用问题来考虑，就是刚刚结束的亚运会这个361叫孙杨的这个穿衣服的这个问题，在那一天，当然孙杨是一位我们一位蛮厉害的优秀的一位运动员，他也代表我们国家获得了很多的金牌，也是。甚至在一定程度说代表亚洲的这个田径这一块是吧？游泳这一块这个东西，他就是说获得冠军。但是当时大家他在获奖的时候，他穿的是他自己的个人品牌、个人赞助的品牌361。另外一位季新杰呢，穿的是国家统一的这个安踏的品牌。所以说大家就视觉会很强烈。你看这个，这个中间这个是孙杨穿的是安踏的黄色的这个。这个是这个季新杰穿的是安踏的，人家觉得以为是3个国家获奖了，其实就2个国家获奖，是吧？就造成了这样一种视觉上的一个，至少说，那你看当时获奖的是，当然我们恭喜他获得金牌，但是这个衣服确实大家在讨论哈。这个你看就很明显，这个冠军他穿的是自己的衣服，自己赞助的361的衣服。这个季军是安踏的国家统一，就那个衣服，安踏的衣服，对啊，就这个当时讨论了一个热评，这里面其实有几个问题在于，就是说，这个问题里面其实6个赞助合同啊，就是中国奥委会跟安踏的合同，游泳协会孙杨个人与361的这个2个合同。亚奥理事会与361的合同，以及孙杨与2个非体育品牌的合同，就是这个6个合同真是有效的情况下面出现了冲突，那哪一个？那怎么办？是吧？这里面最直接就是孙杨履行361的协议是否构成了对安踏协议的违约或者侵权。所以我们当时其实蛮有意思的，当时在讨论就是说，这个说孙杨没有这个契约精神，但是另外一种观点说孙杨太有契约精神了，他对自己赞助的坚持，任何场合都是你再怎么批评我就穿我的赞助的衣服。但是当然另外更高一个层面的话，就是国家这个奥委会还有亚理事会之间是有签那个安踏的那个合同，这2个里面效力谁考虑？但是在里面。当然，现在目前这个事蛮有意思的，因为是我们国家体育总局是没说话了，安踏也是发表了一个意见，认为一个国家不能说2件衣服这个意思哈，国家层面的，但是局里是没有说话的这个事儿，所以说现在也是慢慢开始在民间发酵，但是在体制方面还没有去反映和这个考虑怎么去解决这个问题，但这个问题其实很重要，我们觉得就是说我们在法律或者学者方面考虑哈，因为可能会造成一个后果，就是大家都觉得没有处理啊，谁都爱怎么穿怎么穿嘛，是吧？个人赞助啊，爱怎么弄怎么弄嘛，那这样可能就反而在更大的一个层面，导致了大家不守法律，没有这个法治的意识和法治的精神这一块，看起来如果后细理的话，可能会导致这里面更加麻烦。但里面其实有一条是像亚洲奥林匹克理事会关于2018年雅加达巨港亚运会的商业指引里面是有一点的，第1点，第2条里面规定，禁止除服装或运动装备生产商以外的商业标志出现在运动员或其他亚运会参与者的衣服、服饰或其他穿戴装备、比赛装备上面，它有这么一条禁止这样一个东西。从这个商业指引来说的话，还是在一定程度上，我们不好说孙杨违反了，或者孙杨这个赞助或者361这个赞助在一定程度上可能这种方式可能是违反了这个东西。对， 对啊，所以我们觉得在这个里面，就是说，在这个事情反映出来的话，我们在这个机制、决策机制、商业权利保护这一块都应该去完善。处罚的机制也应该有完善，还有纠错的机制也有完善。这个事情其实我们跟这个后来跟这个因为安踏361都很熟悉的一些朋友聊一下，其实都是觉得好像不是这个是不太合适，反正没有赢家吧。我觉得对于这个整个事，对孙杨，对于总局，对于这些赞助商，好像都没有说谁赢的这样一个状态。其实 ，OK， 谢谢你。
我觉得这个案件是一个典型的事件案件。那事件案件对于这个品牌方来说，像不管361还是安踏，在这个事件上，他们都取得了充分的这个曝光，而且要不然不是这个事件的话，可能很多人都不会关注到底是谁在赞助什么，他们的权益是什么。
你这个是从广告宣传或者那种曝光的那个效果上面来考虑的，但是我们从法律的层面角度考虑的话，你到底这个权利义务这个东西来考虑，就是可能一个，就像我们说的好事不出门，坏事传千里，是吧？它虽然可能达到一个传千里的一个目的，但我觉得可能是不是这样一个。另外很简单说一个案例，就是说这个海牙足球俱乐部和利万盛的一个投资的案例。这个案例是比较有趣的一个案例，就是2015年，和利万盛收购了海牙足球俱乐部98%的股份，但当时根据这个协议呢，和利万盛是应该付多少钱，到了16年4月份的话，他还应该支付247万，但是他最后面没有到期，最后面海南荷兰这个俱乐部在地方法庭就起诉这个，因为和利万盛是中方的，这中资的，但后来法院那个做出了一个裁定，说应该和利万盛向俱乐部去支付这个拖欠款项247万欧元。这个里面的观点会蛮有意思的，但其实从这个观点里面能看出来一些东西。原告方就是说这个足球俱乐部海牙足球俱乐部说，和利万盛干涉董事会、监事会组成，和利万盛和这个老总呢直接干涉俱乐部的事务，包括转会，和利万盛没有按时支付投资款。被告方呢认为是和利万盛已支付了560多万，但俱乐部呢隐瞒经营信息，并在媒体抹黑和利万盛。俱乐部呢持续下降的赞助收益无法实现好的商业目的，俱乐部没有使用和利万盛指定的中方教练，而且俱乐部的经济危机是由于代于收取第三方的款项造成的。从这个里面看出来，就是他这个投资里面，后面发现了各执一词，而且我们相信这些情况可能是存在的。那这个问题在哪里呢？这个为什么后来输了呢？其实就是说，这个案件里面最重要的一个就在交割的是这个交易条件呢，他们没有说对这个怎么股权交割啊、付款前提条件呐、墓碑公司无法实现这些都没有进行是约定，没有约定，因为当时他们请的是当地的一个小的律所，然后就是这种deal这种商业的条款他们不看，就整个交易的条款它是这个我们看不懂，我不看，你们自己决定。他就看其他的一些简单的表面的条款，所以导致了后面出现这些问题。其实这个是很核心的问题，这个交易条款，这个导致了这些问题。当时导致了还有一个很重要的问题就是章程改变，当时交割没有完成，又没法去行使这个管理权限，导致了有钱不敢付，这面出现这种情况。所以这个投资有很大的风险，当然里面还有一些理念的问题，就是说文化的问题，欧洲跟这个中国的文化的问题，因为中国可能还是资本为王这种感觉，是吧？在欧洲的话，还觉得因为很多俱乐部是跟当地的社区是有联系的，当地的社区，它有一些权利啊，有一些什么的，所以说导致了这个后续一个很糟糕的一个情况。那我们建议就是说，其实这个deal啊，这个激励机制啊，这些交易条件，其实也很充分的去进行沟通和约定，包括这个管理层，对。这个后面的现在大概几点了？ 我没带时间啊。这后面是个阴阳合同的问题，就是当时也是一个案件，就是为了这个案件不讲了吧，基于我们这边有外币，就是阴阳合同，反正就是说也是可能就国内存在这个情况，因为限行令导致了就是说签了2个合同，后来还是支持了按实际上那个重要的那个合同去做。还有一个，这个是高管不当行为，这个是就是当时这个高管周尔集团呢，微博上面说不看了，我们可能赢了对手，但肯定赢不了裁判。这样的话，足协当时就做了这个处罚。所以说，足协的这个纪律委员会准则里面是有一个办法的，不负责任的评论，运动员、官员、俱乐部、球队通过新闻媒体发表与比赛相关的不负责任的评论的方式，蓄意攻击比赛官员、其他运动员、这些情况的话是要处罚的。所以当时他在微博上面直接表达说我不看了，可能这样子一个情况。所以现在可能就 OK。所以我们认为就是说，在这个个体言论自由和体育运动形象之间一个平衡，运动员在这一块，这块一会现在 OK， 我提前了5分钟讲完，谢谢大家。